SJC-13063, Commonwealth versus Darius, Gamboa.
Attorney O'Brien, we're ready for you.
Yes, thank you, Your Honors. May it please the court, Jennifer O'Brien for the defendant on appeal, Darius Gamboa. As you know, the defendant was convicted of first-degree murder. I do have several issues. I'll jump right into the first issue, which was that a mistrial should have been granted per defense counsel's request when one of the witnesses, Mr. Pina, testified that he saw the defendant at the scene of the shooting. Now, there was a motion to suppress the identification by this particular witness prior to trial. That was allowed by the court. And while Mr. Pina was testifying, he suddenly testified, quote, "Darius came up to me and I said, 'What's up?' to Darius." So this was objected to. Yes.
Counsel, may I ask you a question? What about the judge? The judge issued, they struck the testimony. The judge issued a curative instruction. People report they saw the jurors crossing out notes. Why isn't that enough, since we usually assume the jury is following the judge's instructions?
Well, I do agree that the judge did give a very strong instruction. She said that she saw jurors crossing out things in their notebook. I would argue she really doesn't know what they were crossing out, obviously. She wasn't behind them looking at their notebooks. But this case, identification was a real issue. The defendant, it was so important to the defense, I guess is the answer to that, that it wasn't the entire defense, essentially, that the defendant was not present at the scene. But
it was more than that, if I could just say, as it relates to the curative instruction, it was even more than that. The judge also said to the jury, and this is inconsistent with all of his previous statements, which is an important part of the curative instruction here. And then we have a lot of evidence independent of that, that the defendant is in that area of 7-Eleven. And after all, it's his father assailant who is shot.
Yes. Yes.
So as it relates to the issue, there's no doubt it was error. It wasn't an expected answer, but it was error nonetheless. So
yes, and I think that the question is, how much did it matter? There was other evidence that the defendant was at the scene of the crime. It was hotly contested. It was Tyrell Gamboa testified, but he really didn't cooperate at trial. So his grand jury minutes were taken substantively, and the defendant's girlfriend, Miss Oliveira, was a complete mess. It was kind of confusing. She testified differently so many times. She did testify at the grand jury that the defendant admitted his presence at the scene. And that was hotly contested. It was it wasn't a simple single testimony that yes, he told me it happened. They went round and around with Miss Oliveira about whether or not she lied and whether or not the defendant really told her that. So I would agree that those two witnesses did provide evidence that he was at the scene. But as far as being exactly on the corner and what he was wearing, I know it was the Commonwealth's position that what he was wearing and that he was holding a towel. There was evidence of that, but nobody definitively put him at that exact location, and that's where shots were obvious.
It sort of leads into your second argument about the polygraph, because, and you say it was a serious issue of credibility as it relates to Ms. Oliveira. And at one point, Lieutenant Domingos testifies that Oliveira said she'd do well because she was going to be truthful about what she would say, which is improper in and of itself. But it seems that that's in context of the polygraph. So I know your point is that this was hotly contested testimony. And within that analysis, we're looking at the polygraph exacerbating that issue.
Yes, yes, absolutely. The polygraph, the testimony surrounding the polygraph really bolstered Miss Oliveira's testimony. And that obviously, as you stated, is my second issue, that it was unnecessary. There were pages and pages of testimony about how polygraphs are administered, the science behind polygraphs. And it was objected to. I will concede that when the Commonwealth began, or rather when Mr. Domingos began testifying, there's a couple of pages about preliminary polygraph evidence that he doesn't object to, but then he finally goes to sidebar and says, what are we doing here? Like, this isn't coming in. Why are we laying a foundation for a polygraph that isn't even going to happen? And the judge allows it in to rebut the defense's contention that Miss Oliveira was, strong-armed, if you will, or coerced or threatened or harassed to change her testimony.
Isn't that an important part of the defense, that the polygraph, particularly with her, where it's not even turned on, is all coercive and meant to scare her and intimidate her? And that's an important part of the closing of the defense, right?
Well, yes, once it was introduced, but the Commonwealth is the one who introduced it, and the defense counsel did object, but then once it was in, yes, he used it.
Wasn't in the defense's opening? They didn't bring up that in the opening? I don't know. I haven't read the opening.
I believe it was. Yeah, the closing, absolutely. Yes, he did. And he also brought it up with respect to Mr. Pina, that he refused a polygraph because he deemed that they were not reliable. I mean, here, I think with the judge, the reason it appears that the judge allowed this in was because, twofold, really, that defense counsel had argued that she was threatened and coerced and harassed by the police. But also, I think there was a misunderstanding that this was the first time that she, may have, quote, unquote, cracked and finally admitted that everything she had said before was a lie. But that's not entirely true. She was questioned by the police, and she gave the false alibi. She was called before the grand jury on August 16th, and that's when she again gave the false alibi. After that, she testified that she was, called a liar, and mostly by the assistant district attorney, not the one who tried this case, but another one, called a liar. Her life is over. And a couple of weeks later, she was summoned back to the grand jury to testify again. And that is when she was ultimately called a liar again and arrested. September 3rd is when she had a meeting. She was in custody and she had a meeting with the district attorney, a few police officers, and her own attorney. And that is when she came clean and gave up her alibi and agreed to testify honestly, if you will. And then she was recalled. Then September 5th happened. She had this sit down with this detective. And then right after that, she testified before the grand jury. So I think the judge was under the impression that this is, the first time that she had changed her story, but it really wasn't. It was when her attorney was there and she had to sit down. I'm sorry.
No, I mean, she changes her story 4 or 5 times, but the judge also gives this very lengthy curative instruction on polygraph, right? That it's not admissible, it's not reliable. You're only to consider it for basically the coercive tactics, whether it was coercive or not, right?
Yes, there is an instruction. I'm not denying that at all. I think what made it worse was not just the fact that she was willing to take one, that she testified that she thought she had taken one, but it came out that she was begging to be hooked up to the machine. So it was clear she never really was hooked up to the machine. But I think what made it worse is the introduction of that video. The defense counsel said he'll stipulate that this interrogation or interview or fake polygraph exam, whatever you want to call it, was not coerced, that the detective was calm in his demeanor, and that wasn't enough.
Well, the problem with the stipulation, and Justice Souter wrote an opinion about this in the old chief case. The problem with the stipulation is that that's not going to present a case of not narrative richness. It's going to prove something to a moral certainty. And the defense here, the entire defense here is, and there was evidence to support the defense, that these witnesses were figuratively really badgered and coerced as it relates to their testimony. So the jury needs to see the video to understand from the Commonwealth's perspective, that's not true. A stipulation isn't going to do that.
Well, I understand what you're saying, Your Honor. I think what is important in this case is she never accused this particular officer of coercing her or harassing her. By the time they sat down in this particular interview, she had already changed her story. She had already made up her mind. She gave up her false alibi. And the Commonwealth acknowledged this, in the closing argument, and even in the cross-examination, the direct examination, that she had the meeting with her attorney present, and that was 2 days earlier. So I agree with you if she said that this particular officer was one of the many ones that coerced her, but she didn't. And then we have to obviously weigh the probative value against the prejudice. And this was a 31-minute video that was played. And it wasn't just Ms. Oliveira speaking. There were, it was obviously the detective asking questions. There was a lot of gratuitous comments from him saying, you're really a good person. You're a good girl. His opinion that she was telling the truth. There were prior bad acts that came in. It was her not just agreeing to take a polygraph, but begging to be hooked up, saying, if you don't think I'm telling the truth, then hook me up to the machine. She says that 4 times. And this is
I'm sorry, but before you run out of time, I'd like you to address your third issue, that
Sure.
being the provocation and where the evidence of provocation was to warrant a manslaughter instruction, please.
Okay, sure. So there's obviously an objective and a subjective part. So the evidence that I had with respect to provocation, and I did look at the Commonwealth's brief, and I think with respect to Pina, he was the witness that testified that he seen 2 dudes fighting. I think it was the clerk who initially, Sean DeAndre, who said that he thought the victim had the knife and not the defendant's father. So I think I just to let the clerk know, the court know, I mixed that up, I think, with the witness. But there was testimony that the clerk initially said the other person had the knife. But here, I mean, it was, I know the Commonwealth believes that this was set up, and they have the telephone calls that went back and forth. The evidence shows Darius's father going into the store first. So I don't think it was anticipated. There was no planned meeting. He went in, and the victim came in after him. There's no dispute that at the door when they were leaving, the victim turned and sucker punched the father in the face. And then, according to witnesses, again, the clerk said there was some back and forth, real close. They moved back and close, back and forth out the door and inside and outside. And then they ran, one of them fell, and then they separated. So I think obviously the jury did not have to find manslaughter, but I think the defendant was entitled to the instruction.
You have that altercation, but then it's the ensuing altercation, right? That I know they're all part of the same, but where's the provocation when there's the person shot in the back, correct?
Yes. This happened in a matter of moments, obviously, in a matter of seconds. There's an altercation, they run out together. Yes, there is testimony that the victim is being chased by the defendant's father. But I would argue that there's really not, you know, if the defendant is seeing his father get punched in the face and there's a scuffle and then it, you know, the victim yes.
What's your closest case that would persuade us that the judge should have given the instruction?
Well, I quoted cited the shops case. I mean, that's not a physical altercation, but that stands for, that's where it was a husband and wife, and I guess the wife was having an extramarital affair. And it was really just words there. Here, it was something physical. But as far as the cooling off period, I think there, the defendant, you know, got upset, went to a cabinet for a gun he had loaded, I guess, previously. And the court said that a voluntary manslaughter should have been given there. I mean, here, it's just in a moment of seconds, in an instant where the defendant, he didn't leave the scene and come back and reflect about it. He's seeing his father in a fight. Certainly, it appears that the father was winning the fight. Yes.
So your position is they were in the throes of this fight, and we should look at those types of cases.
Yes. Yes. And I mean, I don't dispute that. Obviously, where the victim was shot in the back, and there are witnesses that testified that the defendant's father gave chase. I don't dispute that he won the fight or was winning the fight or was going after this person. But you know, just looking at it from the defendant's point of view, I mean, this is a family member. This is your father. There was evidence that he believed that people were after his father because he had snitched or was snitching in a previous case. So I think his alert was heightened already. And then seeing an altercation, seeing his father get punched, I think those are the types of cases that should be looked at with this.
Thank you, Mr. Klein.
You're welcome.
So what you would say is you would distinguish Commonwealth versus Brea because it's a family member as opposed to simply a fight. That's the key fact as far as you're concerned, right?
I think it matters. Absolutely. I mean, you're more emotionally invested. You don't just, you know, walking down the street and seeing people fighting. I mean, this is his father that he's close with, obviously. So I think the time for cool reflection should be looked at and you know, subjectively with him and objectively, which it has to.
Why do you think that we should, in our analysis on, if not double jeopardy and if not 33E, at least on whether or not there can be a retrial, if you're correct, it was prejudice from these errors. Why do you say we extract the evidence, certain evidence?
I don't understand your question.
That's okay. I realized the error of my question.
Okay. Hey, unless there are any other questions, I'll rest on my brief.
Thank you.
Thank you.
Attorney Campbell?
Thank you. Good morning. May it please the court, Julianne Campbell on behalf of the Commonwealth. I'm here today asking that this court affirm the defendant's convictions for the murder of Mr. Julio Barbosa. And if I may start with the issue of the polygraph references.
There's a lot of unnecessary polygraph stuff, right?
Yes, and I don't dispute that.
These are shark-infested waters.
Yeah,
They-
they are.
Without a doubt, without a doubt.
Then why?
So what I will say, I was struck in reviewing the cases that I relied on in my brief in preparation for oral argument. I was struck by the language in Corcione, which is 1974 and certainly predates Martinez. But in that case, this court wrote, "This court has not held that otherwise admissible evidence must necessarily be excluded because it contains mention of lie detector tests. there's certainly evidence in this case that was direct to Ms. Oliveira's willingness to take a polygraph, and I'll refer to him as Tyrell's willingness to take a polygraph, and that's improper. The cases make that clear. What I would say with respect to Tyrell's testimony, I think it's on a different footing than Ms. Oliveira's. I would suggest that the Commonwealth did not make use of his, and certainly did not elicit from Tyrell whether or not it was, during Tyrell's testimony, whether he was willing to take a polygraph. It was only upon Tyrell's and Ms. Oliveira's essentially categorizing this as a coercive environment that they gave their statements that this came out.
But why did, as it relates to Tyrell, why testimony that he said he was willing to take a polygraph? I think you concede error quite appropriately there.
Yes.
But why do you need that to sort of rebut the whole idea that the statements are being coerced?
So I think it's the willingness, indicative of a lack of coercement, I think is, and I agree that question would have been better left unsaid. I think if that was the only issue in this case, I would suggest it doesn't amount to prejudice, especially with respect to Tyrell's testimony, given that there was other evidence that tied the defendant to the scene.
Going back to Justice Graziano's statement, which I
Yes.
agree with about shark-infested waters,
Yes.
why do you even have to reference with this witness that he's a polygraph expert to be able to get into what the whole demeanor and approach is to the whole
Sure.
thing?
So I think the lines got blurred with Lieutenant Domingos because, and I'm not trying to sidestep your question, I'm trying to contextualize it in all of the references that came in. And the one about Tyrell is really towards the end, I think, of Lieutenant Domingos's testimony. I think of more concern is certainly the references with respect to Ms. Oliveira's. And while it's shark-infested waters, here it was necessary to explore those waters in an inevitably messy way, but the court, I would suggest the trial judge, tried to make this as clean as possible by emphatically instructing that there's nothing. First off, Ms. Oliveira didn't do a polygraph exam. Secondly, that polygraphs are completely unreliable. The jurors heard that from the court. They heard that from a lay witness. This is not the type of prejudice here, I don't think is the same as what has been in other cases.
It's almost like mentioning the breathalyzer in an OUI case.
I would agree, but it would be the circumstances around the actual breathalyzer that I think were of import to the Commonwealth.
As you know, as a prosecutor, when you know, I'm sure if they asked you before they went to trial, you'd say, boy, I don't know about that as an appellate lawyer. Same as if a district court ADA said, I think I've got an issue involving the breathalyzer, you know, we can get an instruction on this one. You might be in a hot seat in an appellate argument.
I certainly would be, and I am now. I don't dispute that. But I think this is a unique case in that the circumstances surrounding Ms. Oliveira's statements were critical for the jury to observe.
How important was her testimony overall, though?
I think that her testimony is certainly strong evidence for the Commonwealth, and that it's the defendant's own admissions to not only being on scene, but to shooting the victim himself. But obviously she was an important witness for the Commonwealth. I'm not going to understate that.
Really important because she never retracts that the alibi wasn't true at trial. She continues to admit that the alibi wasn't true.
Well, I think that is the case, but she also feigns memory loss at trial. And so her substantive grand jury testimony was admitted, and it was for the jury to assess her credibility. And I understand that the risk of polygraph evidence is that it could influence the jury's assessment of credibility. But in light of this judge's explicit instructions that you're not to use polygraph evidence as evidence of credibility, you are to look at the circumstances surrounding what Ms. Oliveira's statements actually were. And in that way, there simply was no other way, I don't think, for the Commonwealth to rebut the defendant's defense that all of these witnesses were coerced and harassed and pressured into giving the versions that they gave.
Does but the Commonwealth introduces this first, right? This isn't, right? So the Commonwealth gets into the polygraph before the defense. I just glanced at the opening. It says that, you know, it has this sort of vague extracts, they're extracting the testimony, but it's not clear up front the defendant is going to rely on the polygraph as a coercive technique, is it?
I disagree with Your Honor's assessment, and I would point to language from the judge who says it was clear from the outset, from sort of the motions in limine that were litigated. And Ms. Oliveira's testimony itself, I acknowledge that it was the Commonwealth who first brought up the reference to a polygraph, but the way in which it was brought up was after Ms. Oliveira had explained that she had a crazy and emotional conversation with investigators. And I think at that point in which the Commonwealth asked, what were you supposed to do that day? That Ms. Oliveira says, take a lie detector. So, and it was after this, what I would suggest was a hostile witness for the Commonwealth, testifying about what I think amounts to a coercive environment. And it was in that situation that the prosecutor asks, what were you there to do that day? And were you in pain from being hooked up to wires, which Ms. Oliveira volunteered herself? And I think whether she was in pain, whether she was feeling harassed and emotional, all of that was certainly relevant. And when the video was introduced, as the judge articulates, I think at one of the sidebar conferences, the only one raising their voice in that interview is Ms. Oliveira. She is the only one becoming upset and emotional. This was not a coercive environment the way that the defendant had depicted it. And I think, unfortunately, it was inevitable that incidental references to a polygraph were going to come in.
That's probably true, but this wasn't incidental. This was the expert who knows about this stuff, and jurors, people think that polygraphs are lie detectors tests, and I guess what I'd ask you to help us understand is why is the polygraph testimony, as far as whether or not the witnesses were coerced, relevant to show that they weren't coerced, as opposed to being used to say, they're not coercing her, they're just trying to get her to tell the truth, for goodness sakes. They've got a polygraph set up and ready to go. And the second one is not permissible.
Correct. And I'd ask this court to treat the references to Tyrell's polygraph differently because of the fact that I simply think standing alone, even if it was, well, it wasn't, it was inadmissible, the willingness to take it, but in that context, there was other cumulative evidence that placed the defendant on the scene. With respect to Ms. Oliveira.
Although there's a suggestion that Tyrell places him on a scene in a different way than some of the others, right? That I guess the angle is more relevant from Tyrell's perspective or something to that effect, or?
I would suggest only in that it links the defendant and his father together. I think Tyrell is probably the only witness who says they were together immediately before and immediately after, the only on-scene witness, of course. Obviously, Ms. Oliveira references the defendant and his father being together. But I think beyond that, you have phone connections between the two that would establish that. But with respect to Ms. Oliveira, and with respect to the polygraph examiner's testimony, because I think that is critical, I understand that it certainly toes the line, but I think where the witnesses, and it wasn't just Ms. Oliveira and it wasn't just Tyrell, I think the witnesses themselves demonstrate that they felt pressure. And the critical part of Lieutenant Domingos's testimony is that it's actually his goal to not pressure an individual who he's speaking to and intends to polygraph. In fact, he describes how he tries to keep a calm demeanor. And that's for purposes of the polygraph. So again, especially where there was no polygraph done of Ms. Oliveira, I think that testimony was critical for the Commonwealth to rebut the defense notion of this being a coercive environment. And in response to my sister's argument, at least, that, well, Ms. Oliveira was referencing another prosecutor, not the trial prosecutor. That may be so, but the defendant was the one who argued polygraphs or tools of
So can I
coercion.
distill your answer down to my question to see if I have it
Sure.
right? So you're saying that, no, to understand why he goes through all this effort to keep them calm, you need to understand what his ultimate goal is,
Correct.
which is to administer a test that requires calmness.
Correct. Correct.
Although it's a little odd when he's not running the machine. So because he doesn't care about the results here because it's not on, right?
Well, the reason, I think he may have testified, but I believe the record reflects that the reason that there was no it may be in the record, whether it was before the jury, I can't recall, but the reason the polygraph was terminated was because of how emotional Ms. Oliveira got, and they couldn't go through with the exam.
Could you address in a light most favorable to the defendant in this chaos of this fight that is, you know, an episode that happens in seconds, why there was no manslaughter?
I'd suggest that there was no manslaughter instruction and that was an appropriate decision because the defendant now, and suggests at trial this argument for reasonable provocation, but there has to be an objective component of that. And with respect to reasonable provocation here, what we have is the defendant's father got sucker punched and the defendant responded with deadly force using a firearm while the victim was fleeing. As I wrote in my brief, I'm not aware of any case in which deadly force may be used while witnessing another person be punched, and that would justify a reasonable provocation defense.
There was a fight that preceded. He was in I got sucker punched. There was an altercation with the father, correct?
That's correct. The father was punched. I don't dispute that, but I would suggest that objectively speaking, I don't think that should amount to reasonable provocation to use deadly force. And I'd also suggest that
What's the time span between when they leave the store and the shooting?
it's quick. It's certainly quick. There is, I can't answer that directly. I would say within moments. But even so, the reasonable provocation cases where a voluntary manslaughter instruction is warranted differ significantly than this factual situation. And I'd also suggest that even on these facts, in the light most favorable to the defendant, there's, at best, he saw his father get punched and chase the man. And I just don't think that those facts should warrant a reasonable provocation defense. And in this case, I don't think the judge erred in refusing to instruct on voluntary manslaughter.
And at the moment he shot, what was the position of his father and the victim?
So I think the father was chasing the victim. The victim was obviously shot in the back. There's some witness testimony that suggests the victim may have been kneeling or tripped as he had been shot because he was on his knees and then there was a shot and then he fell. I think the witness testimony differed on that, but certainly the victim was being chased.
Can we talk about prejudice for a moment here? And I guess I should just check as a preliminary matter. Do you agree that the polygraph issue was preserved?
No.
Okay, so then your view is there's a substantial likelihood of miscarriage of justice.
It depends on the specific instance. So with respect to so Tyrell was preserved and the objection to the entry of the video was preserved. My position is with respect to the other portions and references to polygraph that they were not preserved. And in fact, there are other instances in where defense counsel references polygraphs that were unobjected to.
All right, so whether it's substantial likelihood or prejudice, tell me why there's, at least from your perspective, no substantial likelihood of miscarriage of justice here as it relates to the polygraph testimony.
So I think the evidence cut both ways. And if anything, I think that the defendant, obviously Ms. Oliveira was an important witness. I don't dispute that. But in terms of substantial likelihood of a miscarriage of justice, I don't think that the case rose and fell with Ms. Oliveira's testimony. There was certainly a significant amount of other testimony that linked the defendant to this incident. On top of that, the Commonwealth completely refrained from using the polygraph references in the impermissible way that this court has cautioned should not be done. And I think that speaks to the fact that the Commonwealth was seeking to explore the circumstances surrounding when the statements were actually made, as opposed to exploiting the willingness to do a polygraph exam. And so for those reasons, I'd suggest there's not a substantial likelihood of a miscarriage
You
of
also
justice.
have to look at the strength or lack of strength of the rest of the case. So
Certainly.
I guess, you know, how strong is it with the towel and the video? Is that strong evidence, or is it murky?
No, I would suggest it's quite strong. So certainly you have the defendant's own statements where he gives an alibi that is later contradicted.
Doesn't that require believing the girlfriend, though?
I would suggest it does not, given the other evidence that places the defendant at the scene. That being, I think the white shirt and the sweat rag is really critical, that he then shows up to interview with the police with a sweat rag, that's an identifying characteristic. The phone calls between the defendant and his father before and after the homicide, the defendant's own statements to other individuals, such as Devin Cuba, his jail call statement. I think there is a significant amount of other evidence, and I think with the judge's instructions regarding the polygraph and the limitations of it, and the limitations of the pre-polygraph interview with Oliveira that were admitted, all of that in the context of the entire case either does not amount to a substantial likelihood of miscarriage of justice where the errors are not preserved, or it certainly was not prejudicial in that it impacted the verdict.
Did you find any other, I know we have no in-state cases on use of the polygraph for this coercive purpose. Did you find any cases out of state that?
The short answer is no, Your Honor, and I apologize to the court for that. Unless there are any further questions, I'm happy to rest on my brief.